LAF number 3, Disarray at the DOJ.
Hi, it's Shan Wu with an undercolor of law analysis of how the Trump DOJ is falling apart under the weight of him, or the weight of his policies. Now, we always hear the media talking about how Trump is stressing out the system, he's pushing the boundaries, pulling all the levers of power, testing what the extent of the legalities are for his authority. Now, what we don't hear much about is how much of a strain that is, not just on the sort of structural system, but how much of a strain it actually is becoming on his own lawyers to keep up with the pace. So let's look at what actually happens with all this litigation that's going on across the country. We hear about it's shock and awe on their part. They want bureaucrats to wake up hating their jobs. Many of us feel overwhelmed. It's hard for us to keep up with how many things are going on. But tonight I want to point out where it's actually hurting his ability and his administration's ability to get stuff done. Yeah, there's a strain on the courts, so let's talk about that first, because it's not that big of a strain. Let's see why. There are 94 federal districts across the country. Each one of them has many trial courts within them. So in total, we have about 670 federal trial court judges. It's actually probably a higher number because when judges take senior status, they can still hear cases. They help bear the overall caseload, but that's kind of not counted in that number, 670 active. So, we have 670, almost 700 federal trial court judges. Then we've got 12 circuit courts of appeals, the federal courts of appeals, including the D.C. Circuit, and that has about 179 judges. Same deal, their senior judges help with that caseload. They sit in panels of 3 here, the appeals court judges, so you got to do a little bit of math to figure out how many panels there are. They may hear stuff en banc, meaning the whole circuit hears it. But a lot of the judges there too. And as we all know, we have the 9 SCOTUS judges, Supreme Court judges, the sacred number of 9. Just kidding, there's nothing sacred about that. It's totally arbitrary. Now, the pace of the cases being filed against Trump is fast. The Supreme Court has a lot of control over what they take. But still, let's look at how many cases are being filed to remind us of that. We'll put up this helpful chart that Vox did, which is based on the Just Security Litigation Tracker, which is a great resource to have. And counting, we've got 139 cases so far. Now, notice how that compares, though. 139 cases, 670 trial courts to handle them, 179 appeal courts judges. That's pretty manageable. Supreme Court only has 9 of them, but they control their docket a lot. But even with them, you see a little bit of a strain, but maybe it's sort of a fake strain. Let's examine why. They are constantly doing these shadow docket cases right now. That's where they give an order. And the order is based on a sort of emergency briefing. You hear that term a lot too, these emergency cases that the Supreme Court is taking. Primarily what that means is there is no time given and not a full briefing on the issues, and oftentimes there's no oral arguments decided on the papers. Now that can be a problem because they could have let the courts below, who have the personnel and the bandwidth to manage this, take care of it. Let the stuff percolate up. Let the record be built, and then if they still think they need to take the case, do the normal briefing schedule. Make a full record, have all the legal arguments put forth, have oral arguments in all the cases. But no, they're in a hurry. And so they intervene in these cases where they don't have to. That's where you're seeing some of the dissents in the last couple of days, where the liberal justices are saying, what's the hurry? Why did you have to meddle in this case right now? Now, we'll talk more about the shadow docket, but that's one big issue with it, hence the term shadow, is that there's no real sunlight on it. I mean, there are some opinions written, there's some dissents, but it's not as fully laid out as a normal Supreme Court case would be. So in one of the dissents recently, this was pointed out, where Justice Jackson said that she actually compared the recent case to the Korematsu decision, which was the notorious one that allowed Japanese Americans to be incarcerated. Even Justice Roberts has once referenced Korematsu as saying it was wrong the day it was decided, and the weight of history has made it even more wrong. Her point, though, was at least It was fully briefed. You understood what the arguments were so that later on it could be overturned because you knew the theory. As she put it, quote, at least when the court went off base in the past, it left a record so posterity could see how it went wrong. For the most part, that's not happening here with the shadow docket, so that's one problem. That's the court system. So it's manageable. The Supreme Court maybe is showing some strain because they're taking so many of these emergency shadow dock cases, but maybe there's something else to that, which is they really want to kind of do everything in a black box when they can help Trump or when they can't help Trump. So that's something to think of, is the strain on the courts. But let's get to the real fun part. What is the strain on Trump's DOJ lawyers? So remember, they have to cover everything that the government litigates. I mean, they are the government's litigators. Now, there are far fewer of them of today. Lots of resignations. They're cutting down on people. They tried to get them to take early retirement, that buyout too. And they're losing a few every day. So this headline from New York Times I found really fascinating as a longtime DOJ veteran. The article says the civil division is now straining under the weight of defending dozens of lawsuits, we know how many, more than dozens really, filed against Mr. Trump's rapid-fire executive actions. It's the civil division because these aren't criminal cases. These are all civil lawsuits that they're defending against Trump's executive orders. The article goes on to say that current former Justice Department litigators say they've never seen anything like this. There's a quote about the velocity, the ferocity of the work is unprecedented, said one retired justice attorney who used to be head of the federal programs branch. Federal programs is tasked with defending all federal programs. Whenever a new federal program is put in place, somebody challenges it, says it's being done wrong, it's unconstitutional, they have to defend it in federal district courts, courts of appeal, and if necessary, it goes all the way up to the Supreme Court. That's just the federal programs branch, okay? This former head of it said that their staff of lawyers used to be about 100 attorneys in that branch. It's been cut to about half that number. All right, half that number, but just since Trump took office, there's almost 150 new cases all fighting these executive orders they have to deal with all across the country. So at this pace, of course, there's, as we know, dozens of these emergency hearings going on because plaintiffs' lawyers are using our friend, the TRO, temporary restraining order, and those are very fast-moving cases. They're immediately asking for that stop right away. Now, some of these press articles have pointed out that the lawyers at DOJ often seem to have little understanding of what the White House is doing. There's a huge disconnect that's beginning to go on. You also have noticed, and we've reported on this before, that you're seeing some very odd people signing the briefs and the orders, and the odd people appearing in court. So, for example, Blanche, Emile Bove, Chad Mizell, that's the AG's chief of staff, these are folks who have signed motions. These are like the top A's, the Deputy Attorney General, the Principal Deputy Associate Attorney General. Having worked at DOJ, it's very hard to convey how big of a bureaucracy this really is. It's just not, it's unheard of to have people at that level personally signing court briefs or actually showing up in court to make the arguments. They should be too busy to do that. And it's always handled by lower level career officials, actually, who really know what they're doing in court. They're there every day. Here's an example of how things are really breaking down. At a recent hearing, this was Judge John Bates, he was pressing a government lawyer to explain why the White House considered a law firm, I think this was the Jenner and Block case, a national security threat. So the DOJ lawyer says, well, it's a national security threat, this law firm, is because the lawyer who left Jenner and Block years ago, Andrew Weissman, had been a deputy to Robert Mueller, the special counsel who investigated Trump. And so the judge says to the DOJ attorney, but he's a former employee. You're not really going to tell me that having someone employed 4 years ago poses some kind of national security threat. Reporting is, after a, quote, pregnant pause, the DOJ lawyer answered, not per se, no, which prompted a bunch of people to start laughing in the courtroom. Once he was further questioned by the judge, that lawyer kind of changed course, saying, well, the national security interests aren't what's really critical in this case. All right. Now, there's some other weird things that have gone on in the hearing. For example, that same lawyer used to work for Pam Bondi in Florida, the new AG, on consumer protection issues. Okay, that's a far cry, right, from national security. And he was actually rushing from one courtroom to another for 2 emergency hearings concerning Trump's bid to undercut law firms. Now, federal court is different than state court, which can be very, very busy. When I prosecuted in the local court in D.C., you had lawyers all the time, defense lawyers as well as prosecutors. You're being called for by different courtrooms. You're like shuttling around. That does not happen in federal district court. Okay, it's very rarefied atmosphere, one case at a time. So having him sort of rush between 2 cases is kind of weird. And the judge, who once headed at my office in D.C., the civil division, so he really knows what he's doing, is Judge Bates, he thought that was very odd. And he said to the lawyer, he said, quote, "The Department of Justice has a lot of lawyers. Why is this all on you?" And that lawyer said, "Well, nobody else was available. Frankly," he said, "I was supposed to be in Florida, but here I am." Judge said, "I don't find that much of an answer," ruled against the Trump administration. Another great example of the disconnect. The lawyer who handled the Abrego Garcia hearing, he was very candid in court, and now he's been disciplined for that candor. When he was questioned by a federal judge, he had conceded that the deportation of Abrego Garcia, who I don't think was deported, I consider him disappeared. After all, he had a court order protecting him. He should have never been taken in the first place. And that DOJ lawyer, who was an immigration division attorney, said he was frustrated when the case landed on his desk. He was a 15-year veteran of the immigration division, the Office of Immigration Litigation, OIL is the acronym. And he asked the judge for 24 hours to persuade his client, that's the United States, if he could persuade them to begin the process of retrieving and repatriating Mr. Garcia. And the point of that was they'd already admitted it was a mistake. Less than 24 hours later, he got fired, basically. He was put on leave because they said that he was not doing a good job. He wasn't advocating properly for the president's agenda. Now, in March, there had been an email announcing this same lawyer's promotion to be acting deputy director of OIL because he was doing such a great job on pushing the administration's immigration laws. So this is hardly like, some buried deep state liberal working against the Trump administration. Nonetheless, when Attorney General Bondi is commenting about that, now remember, this is the Attorney General of the United States commenting on a line prosecutor's personnel issue, okay? She says that he was put on administrative leave on Saturday, on a weekend, and she says, quote, he did not argue that he didn't do a good argument, and he should have argued the judge had no jurisdiction to take the case. And she goes on to say that he, meaning the lawyer, shouldn't have taken the case. He shouldn't have argued it if that's what he was going to do. You have to vigorously argue on behalf of your client. Okay, this is a real misunderstanding of how DOJ works. And she must know how it works because she was once an attorney general in the state of Florida. It's not like some slip and fall case where that lawyer gets to decide, oh, I'm going to take this case or not take the case. He works for the Justice Department. They give him the case. He's got to take it. All right. So maybe instead of bashing her own lawyers, maybe they should be giving their lawyers a little bit of facts and a little bit of law to make the argument. That's why the guy had nothing to say, because he had no information. He's just being told, go out there and defend these things. Just keep defending it. Doesn't matter if you lose all credibility with the court. They probably don't even care if he's making factual representations. When he is honest with the court, and a lawyer has a duty to have candor to the court, this is what happens to him. So that's the strain that is showing on the Trump Justice Department, and that's going to be a problem for them because, one, courts aren't putting any credibility to their arguments anymore. Two, there's an actual physical strain on them shuttling around the country defending all these cases without any time to prepare, very poor communication from the White House besides, carry the water. That's about the only support that they're getting, is being told they better make the arguments. So that's helpful to know, and that's why it's really good that these cases keep getting piled on. The plaintiffs keep making these cases. You'll hear some criticism, like today, there's also a Supreme Court case where they said, again, shadow docket, no standing, right? You'll hear some criticism from on-air attorneys. I heard Ellie Honig criticizing and saying, self-inflicted wound, why weren't they more careful with this? Well, it's not like the Trump administration is being careful. The plaintiffs need to be aggressive. They need to make the cases, file them. Some might get dismissed on technical grounds, some won't. That's litigation, and that's what people are doing. So we'll keep an eye on that for you. Always good to talk to you. Thank you again for replies and comments, and we'll talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.